Hi, everyone. Apologies if if the audio sounds weird. Um, I'm in a slightly different setup, so that might make the audio not as strong. If that is the case, apologies. I'm going to do everything I can to make it level out. Anyway, this week's lecture is all about criminal defenses. So as I've said in the first 4 weeks, a lot of it was just going over things that should already be known. Now we're getting into the nitty gritty. And I'll admit this right now, I'm trying something new with this video. Let me know if it works. If not, we'll figure something else out. So we're talking about criminal defenses, and just in case you do not remember, which I would hope you would, but remember, this is criminal law. There's a difference between civil law and criminal law. When we talk about defenses, we're not talking about civil defenses here. That would be a completely different class. We're talking about criminal defenses. So these are defenses that can be used, or typical strategies that are used in criminal courts and when they talk about defenses. And so this is where the new thing is. Look, see how I have these things highlighted? So throughout this, the highlighted points are the stuff from the textbook that are super important. I try to color coordinate things. So I will be talking through this stuff, but if you are watching this, know that you can follow along in the textbook and see, oh, this is what he's talking about. And so one of the things that we talk about when we're talking about defenses in general is that there is classification, there is organization, much like every other facet of our lives. We tend to, as humans, try to make sense and logic of illogical or messy things. It's just a human nature thing. Even if you're like me and you are fairly messy and scatterbrained, there is still logic. There's still organization to it. So defenses themselves, even criminal defenses, are categorized. And so the very basic breakdown, these are what our textbook will be talking about, the different types of defenses. There's denial or failure of proof defenses. There are affirmative defenses, imperfect defenses, perfect defenses. They can also be factual defenses, legal defenses based on justification defenses, excuse defenses. There's also defenses that are created by a court, or defenses that are created by state or federal legislature. So obviously, as you can see, there's a lot of different types of defenses, and so we are going to talk about a good portion of those, but the important thing is that we're going to go through, in this chapter in particular, it goes through denial or failure proof, affirmative, imperfect, and perfect, as well as talking about factual, legal, justification, and excuse. Where the defenses come from is not discussed in this, but that's partly because it tells you right where it's from in the beginning. So defenses created by a court, these tend to be coming from common law areas, and they can be referred to as common law defenses, or they can be something based off of a law or a statute or something that is created by a state or federal legislature, and that would be a statutory defense, just as a heads up. But that's the extent of what the text talks about, the difference between a created by a court or created by a state or federal legislature. Okay, so denial or failure of proof and affirmative defenses is our first section. Notice I highlighted together. A criminal defendant will be acquitted if the prosecution cannot prove every element of the offense beyond a reasonable doubt. The defendant can either deny that a criminal element exists or simply sit back and wait for the prosecution to fail in meeting its burden of proof. That is referred to as denial or failure of proof defense. You see how I'm doing that, where I highlight the relevant, important information together to point to something. As we get further on, you're going to see more colors and more blending, and it'll make more sense. Anyway, that's just how I'm doing it for this one. So the idea of a denial or failure of proof defense is really, the obvious part is denial. That's, you deny that it exists. But the other option is you just wait to see that, the proof that the defense is trying not the defense, the prosecution is trying to put forward isn't really there. And so that's where we get this failure of proof. Because remember, there is a burden of proof in the court system. When you go to put forward a case and put evidence, you have that burden of proof to prove that this action happened. And so a potential defense that the defense can take is, there's not enough evidence, and so they will not meet that burden of proof, and so they failed to prove. See, that kind of makes sense for the most part, but we'll talk more in depth as things get complicated. So the other one that this little section is talking about is affirmative defenses, and they're not connected to the burden of proof. That's the important piece that needs to be emphasized. An affirmative defense is not connected to the burden of proof. It's specifically the defendant is saying there's a bigger issue that must be proven first. That's what an affirmative defense is. And so I have here the Model Penal Code defines an affirmative defense as a defense that is deemed affirmative in the code or a separate statute, or that, quote, involves a matter of excuse or justification peculiarly within the knowledge of the defendant. So when we talk about this, really what we're getting at is the defendant must assert any affirmative defense before or during the trial, or the defense cannot be used. So what do we mean by this? So we're going to look at an example to kind of explain affirmative defense. So a fight breaks out at a party, and Juan is severely injured. Jasmine and Jerome are arrested and charged for battering. Jerome claims that he did not touch Juan. Someone else battered him. We're going to go right down to the highlighted yellow part. Jerome's claim focuses on the elements of battery and asserts that the elements cannot be proven beyond a reasonable doubt. Technically, Jerome can do nothing and be acquitted if the prosecution fails to prove that he was the criminal actor. Right there. Jerome claims that he did not touch Juan, someone else did. And so, as long as they can prove that, he doesn't have to do anything. Jasmine claims that she did not batter Juan because she was legally defending herself against Juan's attack. Her self-defense claim is an affirmative defense. Jasmine must do something to be acquitted. She must prove that Juan attacked her to a certain evidentiary standard. So the big difference between an affirmative defense and a denial or failure proof defense is what's being required. So a denial or failure of proof is the defense has to do absolutely nothing and just wait for them not to do it. Affirmative defenses are where you have to prove something. She needs to prove, in our example, in a real world situation, if you are the defense, you need to prove that, well, there is this different standard that why I acted is not illegal. So her self-defense claim, she did not batter Juan because she was defending herself. And so we're going to talk a little bit about that in a little bit because it will come back. But those are the basic breakdowns for this. And so the big important thing here is the burden of proof for affirmative defenses. As I said, depending on where you are, not where you are, but it is on the defendant to prove or to get to that point of this is why this matters. And so, as I've said several times before, states vary from place to place on what the laws are. So some states require the defendant to meet the burden of production, but require prosecution to thereafter meet the burden of persuasion. So technically speaking, some states, the defendant has to say, well, this is the situation. So they prove that burden of production. They say, well, this was actually self-defense. And then the prosecution has to have the burden of persuasion where they disprove what was said. Well, and they go, well, it wasn't really self-defense because, and they go through that. So this is something that's important. Sometimes the disproving of the defense is to just a preponderance of the evidence, so it's not really there. Or in some states, it's beyond a reasonable doubt. Here in Pennsylvania, we do require that the defendant meets the burden of production, and the prosecution has to meet the burden of persuasion. However, in Pennsylvania, it is not beyond a reasonable doubt that the burden of persuasion, I almost said burden of prosecution, burden of persuasion does not have to be met, at least not in Pennsylvania. At least not according to what I was able to find in the current legal explanations available. So, understanding that part, now we need to talk about imperfect and perfect defenses. So, depending on the severity of the case and the severity of the offense and whether or not the plan is to exonerate completely or reduce penalty, this is where imperfect and perfect defenses come in. So if a defense reduces severity, that's imperfect. If the defense results in acquittal, it's perfect. So in very easy terms, if the whole point is to make the sentence less, it's imperfect. If the point is to completely let them go, it's a perfect. So that's really what it's saying, because the difference is significant. A defendant who is successful with an imperfect defense is still guilty. But a defendant who is successful with a perfect defense is innocent. So that's why it's important to note that an imperfect defense just reduces, whereas a perfect defense completely gets them off. So, another example, Lulu flies into a rage and kills her sister Lola after she catches Lola sleeping with her fiancé. Lulu is thereafter charged with first-degree murder. Lulu decides to pursue two defenses. First, she claims that the killing should be manslaughter rather than first-degree murder, because she honestly but unreasonably believed Lola was going to attack her, so she thought she was acting in self-defense. And second, she claims she was insane at the time the killing occurred. Manslaughter is imperfect because it's asking for a reduced sentence from first-degree murder to manslaughter, and insanity is a perfect defense that could result in being let go. So, on top of perfect and imperfect, and we need to talk about the difference between factual and legal. And I know that seems really weird, because shouldn't a legal defense be factual, and shouldn't a factual defense be legal? Yes, but we're using these terms slightly different. So if a defense is based on an issue of fact, it's a factual defense. If a defense is based on an issue of law, it's a legal defense. So when we're talking about this, legal defenses is we are trying to look at the way a law is written or what the intention of a law is, whereas a factual defense is looking at something that is a statement of fact. And so they talk about an example of factual and legal defenses, and I just wanted to highlight to identify this. Factual defenses are alibi defenses. These are, you can prove without a shadow of a doubt, realistically, that you have evidence that this person was not at this location at this time. Therefore, it is a fact. It is a factual defense. The expiration of the statute of limitations for a crime, that's a legal defense. You say, well, the statute of limitations for this actual event has expired, and so according to the law, there's no actual point to this. So, again, the terms factual and legal defenses, they mean issues of a fact or issues of the way a law is. I hope that it helps explain that a little bit. So, then we get into justification or excuse. And much like we talked about fact or legal as well as perfect and imperfect, justification and excuse is different. So with the exception of alibis, Most affirmative defenses are based on either justification or excuse. A defense is based on justification will focus on the offense. A defense based on excuse will focus on the defendant. So, a way to hopefully make sense of this. Justification looks at the offense or the crime itself and explains why that situation means it's not illegal. If they're focusing on excuse, the focus is on the defendant, the person who's being charged with the crime, and coming up with a reason why they're not responsible for their actions. So, justification is, we know it's wrong, but the criminal action should be legal in this case. Excuse is saying the person who committed this was not able to. They were not in their right mind. They were unknowing about the situation. And so that's the real basic breakdown of the different categorizations of defenses. So like I said, this is the extent of common law and statutory that they talk about here in this chapter. But these are really good basic breakdowns, viewed from 50,000 feet of this whole chapter, the categorization of defenses. But we're going to get into now some more specific pieces and how these types of defenses will fit into the category. So everything else from chapter 5 and chapter 6 and the rest of this video, all these are going to be about the different types of defenses that are used, and they're going to talk about some of those categories where they fit in. So that is the establishing important piece. Now we get into the nitty-gritty detail. So typically self-defense, this is our first one we're looking at, is justification. It's not an issue of, looking at an excuse for an individual. It's saying, based on this situation, self-defense was warranted. So self-defense can be a defense to assault, battery, and criminal homicide because it always involves the use of force. And that's something that we need to talk about, is that self-defense has to do with the use of force. And hopefully you understand that, but we'll get into it as we talk about some examples. In the majority of states, and this is true, self-defense is a statutory defense. However, it can be modified or expanded by courts on a case-by-case basis. So obviously, this is something that's handled at the larger level, not the larger level, the focused level, but it can be a common law thing if it needs to be, but it really depends on the specific situation. So this is where we get into the wonderfully awkward, how do we talk about it? Most states have special requirements when the defendant uses deadly force in self-defense. I don't think I need to explain what deadly force is, but in case I do, deadly force is defined as any force that could potentially kill. An individual does not have to actually die for it to be considered deadly force. It just has to potentially kill. Deadly force is not you flicked a rock at a person. That's not deadly force. If you actively pushed a large boulder over the edge of a cliff trying to crush someone, that's deadly force. There's a difference. So, examples of deadly force, these are the common ones and people usually know it. Knife, gun, vehicle, even bare hands if there is a disparity in size between two individuals. So we're talking, a professional, beefy, huge wrestling kind of guy that's like 6'4", 300 pounds of just straight muscle versus an everyday, 5'4", 5'5" individual who maybe weighs 130 pounds, 145 pounds. Yeah. If the big muscular wrestle man is going to punch that individual, it could be seen as potentially deadly force. It just depends on that situation. So when we talk about self-defense, obviously they can be perfect or imperfect defenses depending on those circumstances. So if a defendant commits criminal homicide justified by self-defense, that can be acquitted. Or it could be reduced to first or second or even third degree, and have it reduced from murder to manslaughter. And that's the important piece, is that just because self-defense is your defense does not mean that you are not going to get in trouble. That's the important piece. And a lot of people think, oh, well, I'm defending myself, so I can't possibly be in trouble. There is a line. There is a level to this. So the 4 elements that are required to prove self-defense, and it goes through first, and there are some exceptions, but the defendant needs to prove that they were confronted with an unprovoked attack. This is important. The attack needs to be unprovoked. It's not you said you were doing fighting words. You weren't instigating that situation. It was an unprovoked attack. There's a reason why it says with exceptions, because there are some implied things with that. Second, defendant must prove that the threat of injury or death was imminent. And this is important. Imminent. You need to prove that the threat of injury or death is not something that will happen later. It's going to happen right now, in that moment. The third thing is they need to prove the degree of force used in self-defense was reasonable, objectively reasonable under the circumstances. You believe that you were going to be killed, therefore you killed. That's reasonable, objectively, under the circumstances. And then fourth, defendant needs to prove that they had an objectively reasonable fear that they were going to be injured or killed unless they used self-defense. And this gets into something that we're going to talk about. It's a running to the wall kind of issue where some states have laws where you have to run away first before you can act in self-defense. And that's why they say it's objectively reasonable fear that if they did anything else, it wouldn't work. And so they need to use self-defense. And so just here, the model penal code defines it as justifiable when the actor believes that such force is immediately necessary for the purpose of protecting himself against the use of unlawful force by such other person on the present occasion. It says all those same things just in one nice little fancy lawyer speak sentence. And so remember, this is where I said, in general, if the defendant initiates an attack against another, the defendant cannot claim self-defense. This is what I meant by there are exceptions. If you provoke the situation, typically you cannot claim self-defense. It has to be unprovoked. And so the rule has 2 exceptions. And notice, 2. 1, the defendant can be the initial aggressor and still raise a self-defense claim if the attacked individual responds with excessive force under the circumstances. Or the second option is if the defendant withdraws from the attack and the attacked individual persists. So if you started the fight and then, submitted and said, I'm done, I'm sorry, and tried to stop it, and the individual continues to use severe force, yes, you are technically justified even though you started it. And then obviously the first one, if, you slapped someone's arm and they responded by pulling a gun on you, that's a very big difference. And so self-defense would not say, well, you slapped him and he pulled a gun, so when you killed him, that was not justified. No, they're going to be like, a slap to a gun pointed is not the same level. And so this is where we get this conversation about excessive force, and there are exceptions regarding excessive force. So in some jurisdictions, an individual cannot respond to the defendant's attack using excessive force under the circumstances. So they cannot use deadly force when the defendant initiates an attack using non-deadly force. So in my previous example, you can't use a gun if someone just smacked your arm. But if an individual does resort to deadly force with a non-deadly force, the defendant can use reasonable force in self-defense. All right. And so, look at that. Slap on the face, carving knife. I was going to say, it wasn't the same example. But yeah, typically it's some kind of escalation. So this is where like I said, the withdrawal thing, or the run to the wall, so there is a withdrawal exception. In some jurisdictions, the defendant can be the initial aggressor and still use force in self-defense if they withdraw from the attack and communicates this withdrawal to the attacked individual. So obviously, New York penal law is one of those states, and this is where the text is pulling it from. But if the attacked individual persists in using force against the defendant after the defendant withdrew, rather than notifying law enforcement or retreating, the defendant is justified in using force under the circumstances. That's important. Notice, rather than notifying law enforcement or retreating. We're going to talk about this notifying law enforcement in a little bit. And so here we have the withdrawal exception. We're talking about New York's penal law. So, imminence. And this goes back to what I was saying earlier. Imminent means it is immediate and it'll happen now. So notice, defendant cannot use any degree of force in self-defense unless the defendant is faced with an immediate attack, an imminent attack. So if they're threatened with a future attack, the appropriate response is to inform law enforcement so they can incapacitate the threatening individual by arrest or prosecution. When the defendant uses force to remedy a previous attack, this is retaliatory, and a self-defense claim is not appropriate. The legal response is to inform law enforcement so that they can incapacitate the attacker by arrest or prosecution. Imminent attack, if it is happening in that instant or is happening in the very, very, very near future, i.e. the next 5 minutes. Like, not enough time for you to actually call the police. It is happening. That's where self-defense comes in. If it's, I'm going to get you later, or you are going back and getting someone for getting you previously, that's retaliation. That doesn't count. That is not a self-defense situation. And so some state courts have expanded the imminence requirement to include situations where a husband in a domestic violence situation uses force or violence regularly against a defendant, a battered wife, therefore creating a threat of imminent harm every day. In these particular types, this is battered wife defense. The defendant, the battered wife, can legally use force against her abusive husband in self-defense in situations where harm is not necessarily immediate. Obviously, domestic abuse and violence is a very complicated case, even within the criminal justice system. It's still a very he said, she said thing. And so it's difficult to have these kinds of laws and talk about these laws without recognizing that there is some difference and some issues behind this as an overall thing. But I do want to note that this is important, that because of the imminence idea, the imminent danger, if, and this is where battered wife defenses come in, if there is a history of abuse, a jurisdiction, a court can recognize that based off of previous incidents that would also result in imminent harm, and therefore it's self-defense. That's really what it gets into, is it looks at a pattern. So I just wanted to identify that in general. So let's talk about proportionality. And yes, this is a mathematics term in criminal justice. But proportionality, this is where reasonable force and deadly force comes in. So obviously a defendant can't claim self-defense unless the force they used was objectively reasonable under the circumstances. So real quick, what does it mean to be objectively reasonable? Objectively means that it is without emotion. It is based off solely based on facts and data. And reasonable, it is relevant and related to the situation. So objectively reasonable means that it is appropriate and that pretty much anyone else looking at it would say, yeah, that was right. So in general, deadly force can be employed in self-defense when a reasonable person feels threatened with imminent death, serious bodily injury, and in some jurisdictions, a serious felony. Serious bodily injury and serious felony are technical terms that are defined in the statute or case depending on the jurisdiction. So, model penal code states deadly force is not justifiable unless the actor believes that such force is necessary to protect himself against death, serious bodily harm, kidnapping, or sexual intercourse compelled by force or threat. Obviously, this should make sense, what I'm saying, but again, proportionality, it is relative to the crime existing. And so this is where I get into that retreat to the wall thing I mentioned earlier. So duty to retreat. Early common law had this particular rule, retreat to the wall before you use deadly force. The basic idea was that before you could use any kind of deadly force against an attacker, you had to flee to a point where you were backed against a wall. If you cannot run any further, therefore you have to use deadly force to live. That's the idea. Majority of states have rejected this doctrine and instead have the stand your ground if the defendant is not the initial aggressor in the confrontation. I'm sure if you are at all familiar with modern gun laws and the state of Florida is the big one for stand your ground. There's California has some, Texas has them. Like there's a lot of states that actually have stand your ground, but Florida was one of the big ones that really had a big claim. And so stand your ground laws really are just that, if you are put up against a deadly force, you do not have to run away first. You can stand your ground. But obviously there are states that still follow the retreat doctrine, where the defendant has to retreat if there is a reasonable belief that the attacker will cause damage, and that the retreating won't increase the likelihood of death or serious bodily injury, then they're allowed. But if it's reasonable that they can run away, they follow that. Anyway, the model penal code defines the duty to retreat by stating that the use of deadly force is not justifiable if, quote, the actor knows that he can avoid the necessity of using such force with complete safety by retreating. So again, the states and jurisdictions that still follow the retreat doctrine says you can't use deadly force unless you've tried to run away, and in doing so, it's not gotten better, and in fact, you are in more danger. Therefore, go ahead. So, this is where we get into another little more complicated one. There is an established exception to the retreat doctrine in jurisdictions that follow it, and that is defense of the home, which is called castle doctrine, and we'll talk about that in its own separate thing, and it'll be green based off of that highlight. So let's talk about the objectively reasonable fear of injury or death. So a defendant cannot claim self-defense unless a reasonable person in that defendant's situation would believe that self-defense is necessary to avoid injury or death. If the defendant honestly but unreasonably believes self-defense is necessary, a claim of imperfect self-defense may reduce the severity of the offense. However, they're still guilty of a crime, albeit a less serious crime. So that's important. Objectively reasonable fear of injury or death. As we've said before, you cannot just claim self-defense unless another reasonable person would say, yeah, in that situation, it makes sense. If the defendant believes that it was necessary, but a reasonable person would say, not so much, an imperfect self-defense could reduce that overall sentence. So it's important to note that just because you see it as reasonable, someone else might not. So obviously we have an example of unjustified conduct, and this is where I even have a note of going, what? So here's an example back to that difference in body size for being bare hands and to being a crime. So Justin, who weighs over 200 pounds and is 6 feet tall, accidentally bumps into Wanda, a slender 10-year-old child. Wanda spins around and shakes her fist at Justin. Justin responds by shoving Wanda so hard that she crashes into a telephone pole and is killed. I have questions on that part, but Justin probably cannot claim self-defense under these circumstances. A reasonable person would not believe Wanda is about to seriously injure or kill Justin. Like, I think we can all agree on that. So this is where the imperfect self-defense can come in. Imagine that this particular situation, since the abuse, imagine that a slender female 10-year-old severely abused Justin when he was younger. Since that incident, Justin has had an unreasonable fear of female children and honestly believes that they can and will hurt him if provoked. So if the trier of fact, the seeker of truth, the seeker of facts, whatever term you want to use to be the individual who's trying to find the truth in a case, determines that Justin honestly but unreasonably believed that Wanda was about to inflict serious harm, murder would be reduced to manslaughter on a theory of an imperfect self-defense. So this is what I'm trying to say, is that while this situation is very unrealistic and very just not what you would think, a self-defense, imperfect self-defense could be something like this. All right. So other uses of force, and obviously we're going to get into the castle defense here in this. So other than self-defense, and this is important because self-defense literally means defending yourself. There are other legal situations where you can use force to defend something else. And typically it's another person, real or personal property, and we'll talk about what that means, and habitation. And obviously this is one that gets very, very, very heavily talked about, and something we will briefly touch on is law enforcement's use of force in the arrest and capturing of individuals. And we'll talk about that when we get there. So in general, defense of others makes perfect sense. It's where you are acting in defense of another. So in early common law, a defendant could use force to defend another only when the defendant and the person who they are defending had a special relationship, like a family connection. Nowadays, we kind of just gotten rid of that. We're like, anyone can defend anyone. They don't need to know the person. This goes back into Good Samaritan laws where, you're supposed to help, that kind of thing. The other thing, though, is that in most of the jurisdictions that follow this, the defense of others requires the same elements as self-defense. The individual defended must be facing an unprovoked imminent attack, and the defendant must use a reasonable degree of force with the reasonable belief that force is necessary to repel the attack. So obviously you can't see someone getting hit and come in and just beat the crap out of someone. That's not how that works. If they look that they're being attacked unprovoked, then yes, you can come in and defend if need be. So occasionally, a defendant uses force to defend another who has no legal right to use force in self-defense. This is an issue. So under common law, a defendant could not use force legally if the individual defended could not use force legally in self-defense. Majority of states allow a defendant to use force to defend another person if it, quote, reasonably appears the use of force is justifiable under the circumstances. So, Model Penal Code says, under the circumstances as the actor believes them to be, the person whom he seeks to protect would be justified in using such protective force. There's a reason for this. So, if the defendant has a subjective belief that the individual defended could use force legally in self-defense, defense of others is appropriate under Model Penal Code. So, subjective belief. We talked about objective. Subjective means personal. Subjective is your personal view of it. So if the defendant has a personal belief in that exact moment that that person is being unprovoked and attacked, I need to help and defend them, they do technically have the defense that says, well, they were acting relative to what they believe was the truth. And so the example that the text gives, I'm not going to go through it, but short and sweet, Alex and Shane, two of our people in this situation, they are aspiring law enforcement officers, and they're doing a training maneuver in a rural area about being in an attack situation. Their instructor, Devin, is watching nearby. So, it's a controlled situation and it is not a real fight. However, as they're about to demonstrate a takedown, man Timmy, who's jogging in the area, dashes over and begins beating on Alex, who is pretending to attack Shane. In that moment, Timmy really believed that Alex was going to hurt Shane, and unfairly. And so he acts. So technically, yes, if he honestly believed that he was in danger, then yes, self-defense is totally okay. When we know the whole situation, it paints a different picture. So that's why I say defense of others. It gets wonky when we talk about some of those things, but in general, it's if you truly believe that someone is in need of help and you are acting with relative force, it is okay. So, defense of property. So, there are certain specified circumstances for use of force for defending property. And this is where we're going to talk about where it gets the weird breakdown of real property versus personal property. Real property is things that are unmovable. This is land and anything that's permanently attached to your land. So if you own the land that your house sits on, anything that is permanently attached to the land that you own is your real property. However, personal property is any movable object. The things in your home. If you have a bookshelf with books, that is personal property. TV, personal property. Couch, personal property. The floorboards, real property. The house itself, real property. The door, real property. Technically, it can be moved, but it is not a, quote, movable object. This is what we mean when we say real property and personal property. Personal property is the things that you can have on your person or you can move relatively, whereas a real property is something that doesn't really move. So, in majority of states, defendant can use force only to defend real personal property if the defendant has an objectively reasonable belief that an imminent threat to damage, destruction, or theft will occur. So this is where we get into that wonderfully awkward area. If there is an objectively reasonable belief. So if someone else looking at the situation goes, oh yeah, there definitely was going to be damage, destruction, or theft, then your self-defense is justified. Model Penal Code says the use of force upon or toward the person of another is justifiable when the actor believes that such force is immediately necessary. A, to prevent or terminate an unlawful entry or other trespass upon land or a trespass against or the unlawful carrying away of tangible, movable property. If the defendant has a subjective belief that force is immediately necessary to protect real or personal property, it's appropriate. That's the big takeaway. This is where things get interesting. The amount of force that they can use is reasonable force. So this also means that a defendant can chase someone who steals personal property and take the item back. Does not mean that you can shoot the person in cold blood as they're running away. No, you chase them. That's not reasonable force. Model Penal Code says the use of force upon or toward the person of another is justifiable when the actor believes that such force is immediate necessary to retake tangible, movable property. In general, Model Penal Code, most states do not authorize the use of deadly force to protect property other than the home under any circumstance. That's why I mentioned that. You can't shoot someone for taking your TV. All right. So this is another interesting one. It comes down to the home laws. Ejection of a trespasser. So a simple trespasser is an individual who is present on real property without consent of the owner. Basic breakdown. Most states authorize the ejection of a trespasser if they are first asked to leave and fail to comply within a reasonable time. So you can't say, get out of my house right now, and then less than 3 seconds later, as they're already beginning to try to get out of your house, you shoot them. That doesn't count. The degree of force that can be used to eject the trespasser is reasonable force under the circumstances. Deadly force is never reasonable to eject a trespasser unless the trespasser threatens imminent deadly force against the defendant or another individual. Obviously, deadly force under this particular type of circumstance is either self-defense or defense of others, not ejection of trespasser. So, again, while it says deadly force is never reasonable to eject a trespasser, boom, that's it. It is never reasonable. The circumstance that led to this being okay comes under self-defense or defense of others, not ejection of a trespasser. But you can force someone out of your house if you have asked them to leave and they have failed to comply within a reasonable time. All right, you see the green back? The green is back, and we're talking about the castle law finally. So defensive habitation is just fancy words for defending your home, defending where you live. So it's defense that applies specifically to your residence. Early common law, a person's home was sacred as their person was, so, and deadly force could be employed to protect it. Majority of states have since created a modern castle law that embodies that idea. So other than the use of deadly force, defense of habitation or defense of your home generally follows the same rules as defense of property, self-defense, and defense of others. Thus, the defense of habitation discussion focuses primarily on the use of deadly force. The first state to expand the defense of habitation to include the use of deadly force was Colorado with its Make My Day self-defense statute. In case you don't know, Make My Day is from an old school Western. The idea is that, you're not going to leave, fine, make my day. So in 2005, Florida began a wave of castle law modifications that resulted in most states revising their defense of habitation laws. So generally, and this is where it's important, 3 elements must be present before the use of deadly force is appropriate to defend habitation under modern castle laws. So number 1, the intruder must actually enter or be in the process of entering the residence owned by the defendant. So they can't be outside looking in. They are actually entered or in the process of entering. This includes intruders who are outside or in the curtilage, which is the protected area around the home. Second, the resident must be occupied when the entry occurs. So, this means that someone is living there. Someone is currently within the residence when the illegal entry occurs. This excludes devices like spring guns that protect unoccupied dwellings with deadly force. So, to reiterate so far, 3 elements for the use of deadly force in a castle law is 1, they have to be actively in or in the process of entering. Someone has to be there when the break-in occurs. It cannot be, a security system you set up. And 3, the defendant must have an objectively reasonable belief that the intruder intends to commit a crime of violence against the occupants. Not that they're planning to come in and just steal things or stay there. That they plan on committing violence against the occupants. Those are the 3 requirements, the 3 elements that need to be present for deadly force to be allowed in this situation. So, again, our usual model penal code says, quote, the use of deadly force is not justifiable unless the actor believes that the person against whom the force is used is attempting to dispossess him of his dwelling or attempting to commit arson, burglary, robbery, or other felonious theft, and either has employed or threatened deadly force, or the use of force other than deadly force would expose the actor or another in his presence to substantial danger of serious bodily harm. Same things I just said. So, majority of states' castle laws abolish any duty to retreat when inside the home. The idea is you're already against the wall. that kind of thing. So Florida's castle law creates a presumption that the defendant has a reasonable fear of imminent peril of death or great bodily injury when the intruder makes an unlawful or forceful entry. This compels the prosecution to disprove the defendant's reasonable belief of death or great bodily injury beyond a reasonable doubt. This is difficult. This is why I say this is important to know all this. The other thing with castle laws is that they have civil immunity and criminal immunity from prosecution. Immunity from prosecution just means that a defendant who complies with the castle law requirements can't be sued for damages or prosecuted for a crime based on injury or death to the intruder. So, to make a long story short, if you were in a jurisdiction that had this very clear castle law and an individual broke into your residence and all the required pieces were met, you were there, they were already in, and there was a reasonable belief that they were going to commit violent crime against you, and you shot them and severely injured them. And the court found, yeah, you were completely reasonable in that. The individual who broke into your home could not sue you, even civilly, for any damages because you complied with the castle law requirements, so you cannot be in trouble or fined for what you did based off of the crime that individual committed. I hope that makes sense. Like I said, Florida is a little bit weird when it comes to that, but it's because it's Florida. I say it lovingly. My girlfriend's from Florida originally. Okay. Now we get to talk about use of force in arresting and apprehension of criminal suspects. So, we hear it talked about a lot, especially in the last 10 years. We've talked a lot about it. So, highlighted, the appropriate use of force during an arrest or apprehension can operate as a defense to assault, battery, false imprisonment, kidnapping, and criminal homicide. Modern law enforcement's ability to use deadly force is governed by the U.S. Constitution. This is important. Yes, officers have a level of discretion that they are allowed to use. They are allowed to use force when arresting or apprehending a suspect. This is legitimately true. This is not opinion. They are allowed to use force. They are allowed to use deadly force, but there are very specific standards that need to be met. And this is where the larger issue that's been going on in the United States for the last few years has been excessive force being used against persons of color because the situation, one of the things that they're allowed to use deadly force when, much like it's believed for you with defending a home or self-defense, reasonable belief that you are going to be severely bodily harmed. And this is where the issue of some police brutality stuff comes in, is because is the force that they're using appropriate? But that's not what we're here to talk about. We're here to talk about the criminal law aspect of it. I just wanted to mention that this is where this conversation comes in. So the U.S. Supreme Court clarified the constitutional standard for law enforcement's use of deadly force in Tennessee versus Garner 1985. In that case, the court invalidated a Tennessee statute that allowed law enforcement to exercise any degree of force to apprehend and arrest a fleeing felon. You can see why this is a problem. Law enforcement officer in Garner admitted that he shot and killed a suspect, reasonably believing he was unarmed. He reasonably believed that the person was unarmed and shot and killed them. We can see that this is an issue. The court held that the Fourth Amendment governed law enforcement's use of deadly force in this situation because the use of deadly force is a, quote, seizure. Thus, law enforcement's use of deadly force must be scrutinized pursuant to the standard of constitutional reasonableness. According to the court, the only constitutionally reasonable circumstances under which law enforcement can use deadly force to arrest or apprehend a fleeing felon is when law enforcement has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. This is why we get into the argument about it. 1985. Supreme Court said, nope, you cannot just do whatever you want. You need to be under these circumstances. And as we talked about specifically with the castle laws and defending yourself, it's hard to prove you felt threatened. That's why these cases, other than the fact that they're of police officers, they are very difficult to talk about and difficult to look at. So under Garner, these statutes must restrict the lawful use of deadly force to potentially deadly situations. If a law enforcement officer exceeds the use of force permitted under the circumstances, the law enforcement officer could be prosecuted for a crime or sued for civil damages or potentially both. This is the checks and balance system. Does it work out perfectly? Unfortunately, not. All right. So I'm going to continue going through chapter 5, and then when we go to chapter 6, I'll stop and we'll do a separate video for that. So defenses based on choices, these are interesting. So occasionally, law protects a defendant from criminal responsibility when the defendant has no choice but to commit the crime. And so this is where we get a choice of evils defense. And you've probably heard this idea before. You might not have heard the exact term, but you're familiar with this. So it's sometimes called the necessity defense in some jurisdictions. But the idea is that a defendant is protected from criminal responsibility when they committed a crime to avoid a greater imminent harm. So modern penal code says conduct which the actor believes to be necessary to avoid harm or evil is justifiable provided that A, the harm or evil sought to be avoided by such conduct is greater than that sought to be prevented by the law defining the offense charged. In other words, you picked the lesser of two evils. That's why I said I'm sure you're familiar with this. So obviously with this, much like everything else, there's elements that are required. And the three elements of a choice of evil is first, there must be more than one harm that will occur under the circumstances. Usually the harms are the product of nature or are circumstances beyond the defendant's control. You're in that situation, you cannot actively change it other than breaking the law. Second, the harms must be ranked with one of the harms ranked more severely than the other. So ranking is generally up to the legislature or common law, but in many jurisdictions, loss of life is never justifiable under this defense because you can't rank lower than any other harm. Like taking a life is top level at like 99.99% of all jurisdictions. So plain and simple, number one, you have to be backed into that corner, and number two, you have to be able to rank the harm. You have to be able to rank the evils. You have to be able to rank the crimes and say, well, this one is less severe than this one. And then third, defendant must have an objectively reasonable belief that the greater harm is imminent and can only be avoided by committing the crime that results in the lesser harm. Are we noticing objectively reasonable and imminent has come up in all of these so far? I'm hoping that sticks out to you, that objectively reasonable belief and imminent harm are two of the key pieces of any kind of defense. So hopefully that hint, hint, nudge, nudge works. So an example of the choice of evils defense, I really think this is a good one. I'm going to do a 50,000 feet view. Tamara is an individual who gets lost while hiking in the woods, and the threat of, nightfall, and she has nowhere to camp, and temperature's dropping and things are happening. She comes across a locked cabin. She makes a decision. She breaks the window and climbs inside. Obviously, that's breaking and entering. That is illegal. If she, once inside, decides to, because she's starving, eat some food from the house, she's also stealing. So that is also illegal. And if she uses the phone to call law enforcement so, she can get rescued and taken out of there, she could argue that, it's objectively reasonable that she broke in, entered the cabin, and took some of that person's stuff so that she could avoid death. So clearly there is a balance. And so that one, typically they would be like, yeah, she didn't really commit these crimes knowingly. Now, if, say, when she broke in and she took some food, maybe she also took some jewelry or a painting or something, then that's not justifiable. That's, intended to steal that. And the same would be if the cabin's owner said, no, you can't come in, and she decided, well, I'm going to kill you and then I'll come in anyway. Again, you can't kill someone. Killing is the top tier. That evil is worse than breaking in. So, yeah. So this is where that idea comes in, that the lesser of evils, the choice of evils defense is just you pick the lesser of two evils to survive, essentially. So the choice of evils defense can also be a duress defense in some jurisdictions, potentially because if the choice of evils is deliberately brought on by another individual rather than by nature, act of God, circumstances, whatever you want to say. So duress defense, as the Model Penal Code says, is an affirmative defense. Notice affirmative. An affirmative defense that the actor engaged in the conduct because he was coerced to do so by the use of or the threat to use unlawful force against their person. So the duress idea is that you committed a crime because you were forced to. You were under the threat of some kind of force that you had to do this. So, again, elements required for this. First, the defendant or another person must face a threat of imminent, seriously bodily injury or death. If you're familiar with the pizza bomber case from here in Erie, the delivery individual, that family could make the claim that it was duress. They stole from a bank because they faced a threat of imminent, seriously bodily injury or death. Second, the defendant must have objectively reasonable belief that the only way to avoid the serious bodily injury or death is to commit the crime at issue. Again, pizza bomber case. It's the only way to get the bomb color off. Third, in most jurisdictions, the crime committed cannot be criminal homicide. Again, look at that. Works perfectly. And that's not even the example that they have duress. They have a bank teller who gives money to the bank robber. They pointed a gun at the individual. Technically, she broke the law. She embezzled. She took money away from the bank. But any reasonable person would be like, she was under duress. She did not do it knowingly. So it's just one of those. Okay. So consent in 2023, I can't believe that we have to have the conversation of consent in dating and in that aspect. But when it comes to the criminal justice system, consent is also related to that, but it's other things too, and we'll talk about that. So consent by the victim can also form the basis of a justification defense to criminal conduct. Consent is most commonly used as a defense to sex crimes, such as sexual assault, and a lack of consent is a criminal element in most sexual offenses that must be proven beyond a reasonable doubt. So, yes, this is closely related to sexual assault, but there are some other pieces that consent matters. So, it can be a valid defense for a crime only if the victim chooses to render it. So, it must be proffered knowing and voluntarily, or it is ineffective. Model Penal Code, it's ineffective if it is given by a person who is legally incompetent to authorize the conduct. It is given by a person who, by reason of youth, mental disease, or defect, or intoxication, is manifestly unable to make a reasonable judgment. It is induced by force, duress, or deception. Consent is not knowing if it is given by an individual who's too young, mentally incompetent, or intoxicated. In general, consent is not voluntary if it is induced by force, threat of force, or trickery. This is what we talk about. So, technically speaking, the example from the text is a little ridiculous, but it is a assault, battery, potentially sexual assault kind of case with pin the tail on the donkey. But the important piece is consent matters. So, a situation where consent can operate as a defense. Consent is a defense to only a few crimes. Notice I highlighted that in red. I want you to know that. It might show up on the final. It might be something that we talk about. Consent can operate only as a defense to sexual conduct injury that occurs during a sporting event, and crimes that do not result in serious bodily injury or death. So remember how I said consent is mostly sexual conduct or sexual assault, but it's others? This is where it gets confusing. Model Penal Code says when conduct is charged to constitute an offense because it causes or threatens bodily harm, consent to such conduct or to the infliction of such harm is a defense if A, the bodily harm consented to or threatened by the conduct consented to is not serious, or B, the conduct and the harm are reasonably foreseeable hazards or of joint participation in a lawful athletic contest or competitive sport. Long story short, one thing with consent is that injury during sporting events, clearly consent matters. You consented to participate in that sport, so a certain level of injury is agreed upon within some sports. So a hockey player cannot criminally charge another hockey player with assault when during the game, they head-on came against them and they got into a fight. Technically, fights are not part of hockey, but they are. This is where we say a sporting event, you have legal consent. You do not, you can't sue another hockey player for that. I shouldn't have to explain the sexual assault piece, but just to briefly cover what that means, going back to the idea that it's done not, consent is knowingly saying yes. Obviously, situations where you cannot say yes, that is not okay. They mention due to youth, so anything involving children, they are too young to give appropriate, proper consent. So anything, whether it's sexual conduct, which it shouldn't be, injury or anything like that, they can't give consent. Number two, intoxication or mental situations cannot quantify that. So it's important to note that consent, in no matter what it is, in the three situations where a defense of consent matters is sexual assault, sporting events, and crimes that don't result in serious bodily harm or injury. All right. And so that's chapter 5. Like I said, this has gone on quite long, so I'll stop this one. We'll pick up with chapter 6, which is just more in particular defenses. So, yep. Sorry that this is so long. I apologize. I'll try to make the next one a little bit quicker and a little more focused. But yeah, I'll see you in the next one.